Lesson 4. Exclusion. It would cause serious harm to the stability of marriage and to its sacred nature if the fact of the simulation was not formulated concretely on the part of the alleged simulator in a positive act of the will. St. John Paul II, 1993. Since around 85% of our causes at the Metropolitan Tribunal are proposed under the grounds of Lessons 3 and 4, most of your cases will likely be incapacities and exclusions. You already know the fundamentals of incapacity. Let us focus now on exclusion. 1. Positive act of the will. According to Canon 1101, paragraph 1, the internal consent of the mind is presumed to conform to the words and signs used in celebrating the marriage. Paragraph 2. If, however, either or both of the parties, by a positive act of the will, exclude marriage itself, some essential element of marriage, or some essential property of marriage, the party contracts invalidly. The positive act of the will of paragraph 2 is the heart of exclusion, and it is going to be our focus in this lesson. Like the anomaly was the center of incapacity, the act of the will is the center of exclusion. Exclusion is an act of the will against marriage. To be more precise, exclusion is an act of the will against the other act of the will that consents to marriage. To be even more precise, it is an act of the will against the act of consent to marriage itself or to some essential element of marriage. Let us explain this step by step. When we say that the act of the will is positive, we do not mean that it is good. Positive means that it existed, that it was actually issued by the will. A hypothetical exclusion, for instance, had I known this, I wouldn't have married you, is not positive. Indeed, had the hypothesis been verified, the exclusion would have been placed, but in reality, it was not. This positive act is issued at the wedding, not afterward. Exclusion is a determinate refusal, not a mere absence of consideration or interest. It is not willing, in Latin non velle, but willing not, velle non. Moreover, ideas, convictions, and beliefs are not acts of the will. They belong to the intellect. The exclusion is a deliberate intention, a choice made at the same time as the consent. In case of exclusion, we consider two acts of the will: the consent to marriage and the refusal of marriage itself or an essential element of marriage. When the will to marry is stronger, the will to exclude is irrelevant. When the will to exclude is stronger, the consent is invalid. In canonical terms, the consent is vitiated when the exclusion is prevalent. The object of exclusion is either marriage itself or something essential to marriage. If someone rejects marriage as such, there is no consent at all. On the other hand, someone who rejects part of the essence of marriage does not really want to marry. Indeed, a marriage deprived of something essential is not marriage anymore. For instance, someone who wants to marry but refuses to have children does not consent to marriage but to a different contract. Indeed, marriage is a sexual partnership ordered to the procreation of offspring. A marriage intentionally deprived of this end is not marriage. Jurisprudence calls the exclusion of marriage itself total simulation, and the exclusion of essential elements partial simulation. While both make marriage invalid, they are different from the perspective of the excluder. Indeed, in partial simulation, there is a subjective will to marry, unsuccessful as it may be. The different grounds of exclusion are configured by the object of the exclusion, not by its outcome, which is the same in all cases, the nullity of consent. The code speaks of essential properties and essential elements. We already know about unity and indissolubility, the essential properties of marriage. The essential elements are the rights and duties that belong to the essence of marriage. We define the essence of marriage in Lesson 1 as well. Exclusion is called simulation. This term, coined by the jurisprudence, underlines the discrepancy between the words and the intention of the parties at the wedding. In this sense, those who exclude simulate their real intentions. They deceive the other party or the authority that receives the consents. Canon 1101 presumes the conformity between the words and signs and the intention of the mind, but recognizes that it is possible that words and intentions are actually at odds with each other. While this discrepancy is very common in cases of exclusion, at least in theory, it is possible to exclude an essential element of marriage without any intention to deceive. Of course, this is impossible in canonical weddings because the officiant asks specifically about the essential content of marriage. But in other contexts, the excluder could be honest and forthcoming about the exclusion, and the marriage would be invalid as well. Two, total simulation. Total simulation is the exclusion of marriage itself. It takes place when someone wants the appearance of a wedding, but does not want marriage at all, or the other party as a spouse, and refuses to assume any matrimonial obligation at all. Total simulation is not a common ground. In our tribunal, we have only considered this ground in the last years for so-called green card marriages. In these cases, there was a fraudulent intention to deceive the U.S. government, obtaining migratory benefits from a false marriage. The parties never lived together, they had no intention to bear children, and a sum of money was paid by the immigrant party to the other one in exchange. Total simulation can happen in other cases as well, like in post-marriages, where one party feigns consent, or in cases of rejection of the matrimonial institution as such. However, there is no total simulation when the marriage is celebrated for reasons other than love. There are no valid reasons to celebrate a marriage. In terms of validity, the motivations are irrelevant. What matters is what the parties choose, not why they chose it. For instance, someone who gets married to obtain a green card, to avoid poverty, or to please a dying father gets validly married as long as the will is to embrace the obligations of marriage. What makes the marriage invalid in cases of total simulation is not the morally dubious motivation, but the feigned act of consent. Case 1. Tina paid John $5,000 to help her stay in the USA. They married civilly and they rehearsed their story to make it seem real at the interview with USCIS. Their marriage was never consummated and they never lived under the same roof. They just met a few times and they divorced 2 years later. 3. Exclusion of indissolubility. According to Canon 1101, the exclusion of any essential element makes marriage invalid. In theory, there are as many exclusion grounds as essential elements in marriage. Jurisprudence, however, has traditionally employed the three goods described by St. Augustine to consider grounds of exclusion. We spoke about the tria bona in Lesson 1, sacramenti, prolis, and fidei. These three traditional grounds of exclusion are the most common in ecclesiastical tribunals. We will begin with the ground of exclusion of indissolubility, or exclusion contra bonum sacramenti. This exclusion takes place when either or both parties want to keep for themselves the right to dissolve the marriage. In other words, exclusion of indissolubility is the deliberate refusal to assume the duty to stay in the marriage until death. In practice, this means that the right to divorce is so important at the time of the wedding that it becomes a condition of the consent. The act of the will could be expressed like this: I marry you, but I want to be able to divorce you. And if I'm not, I don't want to marry you. As we said above, exclusions are different from ideas. This means that the exclusion of indissolubility is not the foresight or fear of the possibility of divorce. It is not a general acceptance of divorce either. The mere agreement with mainstream ideas about divorce is not grounds for nullity. On the contrary, even those who consider divorce a good thing do not usually apply this idea to their particular marriage. On the day of the wedding, most people want to grow old together and live a happy and successful marriage until death. They are not thinking about divorce, let alone about making sure that divorce is a right they can use down the road if things do not work. Typically, the excluder has particular concerns about the other party. In most of our cases, something happened short before the wedding that moved either party to exclude indissolubility. As with all exclusions, the act of the will must be issued at the time of the consent. Filing for divorce certainly goes against indissolubility, but it does not make the marriage invalid. Divorce makes marriage fail. Excluding indissolubility from the consent at the time of the wedding makes marriage invalid. Divorce itself is not full proof of the exclusion. However, it may be a strong indicator, particularly if the alleged excluder files for divorce shortly after the wedding. The difference between proof and indication is very important. Indications or signs that point towards the fact of the exclusion are very important, but they do not constitute sufficient proof in themselves. For instance, prenuptial agreements are a typical indication of a will to exclude. However, by themselves, these agreements do not constitute proof of the exclusion of indissolubility. Case 2. After 5 years of living together, Linda gave Matthew an ultimatum. If you don't propose, I'm out of here. Matthew popped out the question, and they set the date right away. As the day was getting closer, however, Matthew had second thoughts and realized that he was not really in love with Linda. He spoke with his father, who had been divorced 5 times. he told Matthew, "Look, son, if you do the right thing, everyone is going to hate you. It's too late to cancel the wedding. Marry her, and you can always get a divorce later." They celebrated the wedding, but Matthew left after just a few months. Case 3. Anthony married Lucy under the condition that they would move from Florida to New York 2 years after the wedding. This was very important for Anthony, who had to travel often to New York for work. Before the wedding, he asked Lucy to promise him that they would move. She agreed reluctantly, since her parents were retired in Sarasota, and she wanted to stay close to them. When the time came for the move, Lucy explained that her parents were getting old and sick, and she had decided to stay. Anthony reminded her of her word and pleaded for her to change her mind, but she didn't change her mind. Anthony moved to New York and filed for divorce a few weeks later. 4. Exclusion of children. The exclusion of children, or exclusion contra bonum prolis, is the exclusion of the openness to children, which is an essential goal of marriage. To be more precise, it is the exclusion of the right to the conjugal acts apt in themselves for the procreation of the offspring. The object of the exclusion is not children in general, but the sexual intercourse that leads to procreation. In other words, what is excluded is the right to conceive children through natural means. Exclusion of the offspring is different from sterility. People who suffer from sterility are able to marry, even if they are aware of it. Indeed, those who cannot conceive due to their advanced age or other reasons are able to marry. What makes marriage invalid is not the knowledge that children may not be conceived, but the will to avoid conceiving children. This is not only the case when the parties are determined to use contraceptives whenever they have intercourse, but also when they only want to have sex during the unfertile periods of the woman. Similarly, the exclusion takes place as well when the parties are exclusively open to adopting children, but not to conceiving them naturally. In our tribunal, we have seen this type of exclusion a few times in cases of women who were afraid of the bodily changes brought about by maternity. Surgical sterilization and abortion, on the other hand, are strong indicators of the exclusion. While they do not constitute full proof of the nullity, they are both significant signs of a prevalent will to exclude children. Exclusion of children makes marriage invalid when it is perpetual for the whole duration of the marriage, but it also makes consent null when the exclusion is temporary. If either party excludes the right for a determinate period of time, the marriage is invalid. Cheap and readily available contraceptives have made this temporary exclusion quite common nowadays. There are couples who decide from the onset how many children they want to have. It is relatively frequent as well to delay having children until some professional or financial goal is met, or even to travel around the world and live together before assuming the burdens of parenting. In all these cases of alleged temporary exclusion of children, the key is to distinguish the terminate intention from vague desire. Frequently, it is difficult to know if the parties refused to exchange the right for a determinate period, or if they agreed not to use the right for a while. The difference, quite clear in theory, may be tricky to assess in practice. If we only know that the spouses made a pact to delay children, we presume that the right was exchanged and they just agreed not to use it. Sometimes, however, one of the parties abandons the original plan and wants to have children. When this happens, the answer of the other party is the key to understanding if the exclusion was placed. If they agree to have children, it is a sign that the agreement was only to delay the use of the right. But if the other party refuses, referring to the original agreement, it is a sign that they did not even exchange the right to begin with. Case 4. Marta grew up in Colombia. When she was 12, her mother was abducted by the FARC, never to be seen again. Marta did not know if her mother was alive or dead, or if she was being tortured, raped, or God knows what. Marta suffered so deeply that she resolved never to become a mother, because she couldn't live with the fear that her own children could suffer the same trauma. Before her wedding, she told Julio, the groom, about this resolution of hers. Julio accepted, not without certain sadness. Case 5. Elizabeth was a professional swimmer. Before her wedding to Mark, she made it very clear that they would have to wait until she was done with her swimming career before they could have children. Initially, Mark said that he was happy to oblige, but after a few years, he changed his mind and expressed his desire to become a father. Elizabeth answered, "You cannot ask me that. We said no children until I'm done swimming." Mark's desire grew, and so did his insistence, but Elizabeth did not change her mind. The issue became a big problem for them, and they ended up in divorce. Case 6. Michelle liked children a lot, but her husband Tom was not so fond of them. Tom had been raised with 11 siblings by a couple of struggling farmers. The financial hardship that the family endured took a heavy toll. Tom's parents were always arguing, and he was deeply jealous of his wealthier classmates. Tom explained to Michelle that he was willing to have one kid, and maybe two, but certainly not one more. When he told this to Michelle, she thought it was a joke. But when she got pregnant for the second time, Tom did not get the news with happiness. He looked quite somber, and 1 month later had a vasectomy to make sure they would not conceive any more children. 5. Exclusion of fidelity. The exclusion contra bonum fide is the deliberate refusal to give the exclusive right to sexual intercourse, or more precisely, the intention to withhold the right to such exclusivity. As with all exclusions, the act of the will must be issued at the time of the wedding. Indeed, infidelity after the wedding, painful as it may be, does not make the marriage invalid. On the other hand, if the infidelity is ongoing at the time of the wedding, it is evident that there is a positive act of the will against marital fidelity. Also, like in other types of exclusion, the positive act of the will must not be mistaken with the ideas of the intellect. the knowledge or foreseeing of one's own weakness is not an exclusion. Exclusion is the will to be unfaithful, not the knowledge that fidelity might be difficult. Since the exclusion of fidelity takes place when the right to exclusivity is deliberately withheld, this ground not only takes place when one spouse wants to be secretly unfaithful to the other. The intention to have orgies, threesomes, and any other form of group sex makes marriage invalid. Fetishes, like wanting the other spouse to have intercourse with a third party, are essential violations of the bonum fide as well. However, like with all grounds of exclusion, for the marriage to be invalid, the exclusion needs to be stronger than the matrimonial will itself. This is important because we live in a society where marital infidelity, pornography addiction, and sexual deviance in general are rampant. Many people harbor sexual fantasies in their minds, and they may be willing to put them into practice at some point. But as long as they do not condition the marriage to the verification of the fantasies, the consent is not vitiated. Case 7. Dylan was a pickup artist. For years, he had studied women and how to seduce them. By the time he met Lily, he had already slept with dozens of women. Lily did not know about this, nor that Dylan was still seeing other women during their courtship and engagement. The night before the wedding, he slept with an ex-girlfriend. The marriage lasted only a few years until Lily realized what was going on. After he caught him with another woman for the second time, they separated and she filed for divorce. This was a wake-up call for Dylan, who some years later changed his ways. 6. Difficult grounds. The grounds that we have studied so far in this lesson are very traditional and commonly used in ecclesiastical tribunals. You will probably find them sooner or later in your experience as an advocate. But in theory, there are as many exclusion grounds as essential matrimonial elements. In this sense, we are going to study two difficult and rare grounds: the exclusion of the sacramental dignity of marriage and the exclusion of the good of the spouses. Exclusion of sacramentality. When both parties are baptized, marriage is a sacrament. Therefore, when someone excludes the sacramental dignity of marriage with a prevalent will, there is no consent. While this exclusion is possible in theory, it is very difficult to find it in real life. The exclusion is based on a strong aversion to God and the sacred. However, it is different from not practicing regularly or even from being agnostic. The excluder wants to remove all transcendence, sacramentality, and sacredness from the marriage. This means that for the exclusion of sacramentality to take place, the excluder needs to be aware that marriage is considered a sacred and sacramental reality and deliberately intend to deprive marriage of such quality. Needless to say, both parties must be baptized at the time of the wedding, otherwise there is no sacramentality to exclude from the marriage. As with all exclusions, the will to exclude must be prevalent. That is, it has to be stronger than the will to marry. Therefore, the intention could be expressed like this: I want to marry you, but I don't want this marriage to be a sacrament. And if it is, I don't want to get married. exclusion of the good of the spouses. The exclusion contra bonum conjugum is not a traditional ground. Since a few decades ago, some tribunals began to consider the ground of exclusion of this end of marriage. Certainly, the ends of marriage are essential to marriage precisely because they are the expression of its very nature. Therefore, some authors proposed a new ground of exclusion for the good of the spouses. If it is possible to exclude the good of the offspring, it must be possible to exclude the good of the spouses. However, there are several problems with this ground. First and foremost, since it is an exclusion, the ground requests the existence of a positive intention at the precise time of the wedding to exclude the good of the spouses. It seems very unlikely that someone could marry with the intention to exclude this good. Not any exclusion makes marriage invalid, but only the exclusion of the essential content of a matrimonial right. Therefore, for the marriage to be invalid, the excluder must want, with a positive act of the will, to deprive the other party of any good at all. It is not enough to want something that may cause harm to the other party. It must be an essential exclusion. But who marries with the intention not to promote in any way the good of the other spouse? While this is a theoretical possibility, even the most depraved people want to make their spouses happy in some way when they get married. And this is the key problem with this ground. Simulation is verified only when it is proven that a party rejected by a positive act of the will the obligation at the moment of consent. The fact that a party in the marriage later fails to fulfill an obligation assumed at the wedding does not invalidate matrimonial consent. The exclusion of an obligation at the moment of the exchange of marriage consent cannot be deduced from the mere fact of the non-fulfillment of such an obligation during the marriage. Excursus. Proof. It doesn't matter what I believe. It only matters what I can prove. So please, don't tell me what I know or don't know. I know the law. A Few Good Men, 1992. 1. Favor of the law. According to Canon 1060, marriage possesses the favor of law. Therefore, in case of doubt, the validity of a marriage must be upheld until the contrary is proven. This favor of the law applies to all marriages as soon as the wedding is celebrated, with the only exception of the merely civil marriages of Catholics. Marriages are presumed valid until it is proven in a trial that they are not. In other words, marriage nullity can only be declared in a trial by the judge who has reached moral certainty that the marriage was invalid. And this is where your service as an advocate comes into the picture. Your goal when advocating for a client who wants to obtain a declaration of nullity is to present before the tribunal all the evidence that the marriage was invalid, allowing the judge to become morally certain that the marriage was invalid. Moral certainty was famously defined by Pius XII. Between the two extremes of absolute certainty and quasi-certainty or probability is that moral certainty which is usually involved in the cases submitted to your court. It is characterized, on the positive side, by the exclusion of well-founded or reasonable doubt, and in this respect, it is essentially distinguished from the quasi-certainty which has been mentioned. On the negative side, it does admit the absolute possibility of the contrary, and in this sense, it differs from absolute certainty. The certainty of which we are now speaking is necessary and sufficient for the rendering of a judgment. In simple words, the judge can declare a marriage invalid when he has no reasonable doubt that the marriage was invalid. This is your goal when advocating for nullity, to help create this conviction in the mind of the judge. 2. Proofs. The first part of the trial is the instruction, where the court gathers the proofs. One of your most transcendental responsibilities as an advocate is to make sure that you have proposed all the relevant proofs to make your client's case. The judge gathers the proofs and commits them to the acts of the case. It is essential that everything relevant to the case is contained in this file because, according to an old principle, quod non est in actis, non est in mundo. That is, what is not in the acts is not in the world. If some fact is not contained and proven in the file of the case, the judge cannot take it into account to make his decision. Declarations of the parties. Judicial declarations are the most common means of proof in canonical trials. The parties and the witnesses are cited by the court to offer their testimony about the facts of the case. This interrogation is conducted by the judge, who is assisted by a notary. The judge asks the questions, and the notary drafts the act of the declaration. The tribunal has to make sure that both parties are questioned. Some respondents refuse to take part in the trial, but we have the legal obligation to cite them to the judicial interrogation. Witnesses. Other than the parties, the court summons witnesses to the trial. Witnesses can be proposed by the parties, but they can also be interrogated at the initiative of the judge. Anyone can be a witness, including non-Catholics and non-baptized, but there are some exceptions. Priests are incapable of testifying about what they learn from sacramental confession. Indeed, the secret of confession cannot be violated, even with the permission of the penitent. The sacramental seal of confession belongs only to God. Minors under 14 and those who lack the use of reason cannot be admitted unless for a grave reason. Moreover, clerics do not have the obligation to testify about what they learn from the exercise of their sacred ministry. The same happens with secular professionals who are bound by professional secret. Those who fear dishonor or harassment are exempted from testifying as well. While the law does not forbid the interrogation of the children of the parties, there are several reasons that advise against it. First of all, children rarely know about the facts of the case, since they usually were very young or not born at the time of the wedding. It is also unbecoming to question children about their parents' intimate lives, and it is unfair to involve them in such a painful process. We have never interrogated children of the parties in our tribunal, and we would only do it if the child was the only reliable witness of a fact that is key for the case. It is very important to propose good witnesses. Good witnesses are not necessarily those who knew the parties well at the time of the wedding. That is not the best criterion. Good witnesses are those who know the facts that need to be proven in the case. For instance, in a case of exclusion of children, the mother of the wife may not be as good a witness as her gynecologist. Documents. Both private and public documents can be brought to trial. Public documents can be ecclesiastical, like a baptismal certificate, or civil, like a decree of divorce. Private documents are all other documents, like the letters exchanged by the parties during the engagement. When we study the process, you will see that some documents need to be submitted for all cases, like the marriage certificate. We will study the documentary process as well, which serves to declare the nullity of a marriage when a document establishes with certainty the existence of an impediment or a defect of legitimate form. Experts. The judge is not omniscient. His expertise is limited to the law. That is why sometimes tribunals request the support of an expert in other fields of knowledge. This is usually the case with incapacity grounds. Experts in psychological sciences examine the parties and submit a psychological evaluation to the court so that the tribunal can assess the nature and gravity of the anomaly. Naturally, these experts in psychology must adhere to the principle of Christian anthropology. It is also very important that the expert does not assume the role of the judge. Indeed, in cases of incapacity, the expert is called to assess the anomaly, not the nullity of the marriage. 3. Proof of exclusion. Moral certainty of the nullity is achieved when the proofs contained in the acts demonstrate beyond reasonable doubt that the alleged facts did take place. In this sense, it is particularly important to distinguish allegations from proven facts. In a trial, many claims are alleged by the parties, but only a few are proven beyond reasonable doubt. It is essential not to take at face value the affirmations of the parties and the witnesses. Evidently, the facts that need to be proven in each case depend on the grounds of the case. For instance, in cases of incapacity, it must be clear that the anomaly was present at the time of the wedding and that it limited substantially the intellect and the will. The way to prove grounds of exclusion is clearly established by jurisprudential tradition. Obviously, the first thing that needs to be proven is the existence of the positive act of the will. Since this act is elicited by the will, it remains secret unless the excluder reveals it. Indeed, according to the old adagio, de internis neque ecclesia, that is, not even the church can know the internal forum, but only God. The only way to know that the positive act of the will was issued is the confession of the excluder. In practice, this means that it is difficult to prove grounds of exclusion on the part of the respondent when the respondent does not want to cooperate with the process. Be mindful of this problem when considering grounds of exclusion and avoid petitioning for grounds that will be impossible to prove. The confession can be judicial or extrajudicial. A judicial confession is a declaration before the judge by which a party asserts a fact regarding oneself that is opposed to the validity of the marriage. The extrajudicial confession is brought to trial by witnesses who heard the confession from the excluder. In general, confessions only have full probative force if other elements of proof corroborate them. According to the principle unus testes nullus testes, one witness is the same as 0 witnesses, the confession must be confirmed by at least 2 witnesses. However, in matrimonial trials, the force of full proof can be accorded to the confession of the parties as long as there are no other elements that contradict it. Other than the confession, the judge must be able to identify in the acts of the case the reason that motivated the exclusion or causa simulandi and the reason for the marriage or causa contraendi. These 2 elements are fundamental for the judge to reconstruct the act of exclusion. Moreover, what transpired before, during, and after the wedding must be consistent with the alleged exclusion. These elements are also essential to understand the decision-making process of the exclusion. Canonical jurisprudence calls them antecedent, concomitant, and subsequent circumstances.